All right, let's dive in. Ever feel like the legal system is just this impossibly complicated maze? Well, you're not wrong, but today we're going to hand you the map. We are going to break down the entire Malaysian civil litigation process, step by step, from the very beginning to the very end. So let's get right into it. So here's our game plan for the day. First, we'll get the lay of the land with the court system. Then, we'll talk about the critical prep work you have to do before you even start. After that, it's the paper battle, followed by how you get ready for the actual trial. And finally, we'll cover what happens after the judge makes a decision. Okay, first things first, the court system. Before you take even a single step, you've got to know where you're starting from. This is fundamental. Now, believe it or not, your first big decision is actually pretty straightforward. It all comes down to the money. If your claim is for 100,000 ringgit or less, you're in the magistrate's court. If it's between that and 1 million, you head to the sessions court. And for anything over 1 million, you're in the high court. But here's the thing, you absolutely have to get this right. Filing in the wrong court isn't a small mistake. It can get your entire case thrown out right at the start. You'll waste a ton of time and money, all for nothing. So, once you know which courthouse you're headed to, the real prep work kicks in. We're talking about the pre-litigation phase. And honestly, the stuff you do here can literally win or lose your case before a single legal document is even filed. So what's so essential? Well, first, gather everything. Every email, every contract, every text message, and lock it down. And whatever you do, do not destroy evidence. A judge might just decide that whatever you got rid of would have tanked your case. Second, you gotta do your homework on your opponent. I mean, what's the point of winning a lawsuit against someone who has no money to pay you? A quick company search or an insolvency check can save you a world of pain. And finally, you send a formal letter of demand. This is not just a polite request. It's the first official warning shot. It shows you're serious. And I really can't stress this enough. That early, solid, strategic preparation, it's everything. This is where you build the foundation that your entire case is going to rest on. And speaking of crucial prep, you need to know that a clock starts ticking from the moment the problem happens. And this brings us to probably the single most important deadline in the entire process, the limitation period. For most claims involving contracts or negligence, you have exactly 6 years to file that lawsuit. If you miss that deadline, even by 1 day, your claim is gone. It's barred forever. Doesn't matter how right you were. All right, so you've done your prep, you've met the deadline, now the lawsuit officially begins. The best way to think about this next stage is as a legal battlefield fought entirely on paper. This is where both sides draw their lines in the sand. Now, there are 2 main ways to kick things off. The most common path is a writ of summons. You use this when you and the other side disagree on the facts of what happened, and you're going to need witnesses to come in and testify. The other, more specialized path is an originating summons. You use that when the fight isn't about what happened, but about what a specific law or a clause in a contract actually means. That's usually decided just on documents alone. Once the case is started, you begin this formal back and forth of documents called pleadings. The plaintiff starts by filing their statement of claim, which lays out their whole case. The defendant then has 14 days to file a notice saying, yep, I'm here and I'm fighting this, and then another 14 days to file their defense, where they respond to every single allegation. This whole exchange is so important because it locks in exactly what the dispute is about. No ambushes, no surprises later on at trial. So the battle lines are drawn. Now we're in the phase of getting ready for the main event, the trial itself. And let me tell you, this period is intense. It's filled with what lawyers often call mini battles. The official name for these mini battles is interlocutory applications. Think of them like strategic moves in a chess game before the final showdown. They're basically requests you make to a judge for specific orders that can give you a huge advantage, shape the whole direction of the case, or maybe even end it right then and there. So for example, if you're looking at the other side's case and thinking, there is no way they can win this, you can ask for a summary judgment to get a win without a full trial. Or if their claim is just total nonsense, you can ask the court to strike it out. You can also use a process called discovery to force them to show you all their relevant documents. Or you can get an urgent order, called an injunction, to stop them from doing something, like selling a property that's at the heart of the dispute. And you're not just left to your own devices here. The courts in Malaysia now take a really active role through something called pretrial case management. A judge will basically act like a project manager for your lawsuit, setting strict deadlines for filing documents, exchanging witness statements, Everything really to make sure the case keeps moving and the trial runs efficiently when it happens. So when you finally get to the trial, the real core of it is the witness testimony, and it follows this really clear 3-step dance. First, their own lawyer asks them questions to tell their story. Then, the opposing lawyer gets their turn to poke holes in that story. That's cross-examination. And finally, their own lawyer can ask a few more questions just to clear up anything that got messy. Okay, all the witnesses have testified, the lawyers have made their arguments, and now we're at the final phase. The judge makes a decision. But what happens next? Let's talk about the verdict and the road ahead. Now, here's a serious reality check for a lot of people. Winning your case is often only half the battle. Just because you have a court judgment in your hand doesn't mean money magically appears in your bank account. If the other person doesn't pay up voluntarily, you have to start a whole new process called enforcement. This can mean getting a court order to seize their assets and sell them at auction. Or you could intercept money that someone else owes them, like freezing their bank account. You can even summon them back to court to be questioned about their assets and forced onto a payment plan. So that's what happens if you win. But what if you don't? What if you lose and you're sitting there thinking, the judge completely got this wrong? Well, that's what the appeals process is for. And it's like a very clear ladder. Decisions from the lower courts can be appealed up to the high court decisions can be appealed to the Court of Appeal, and the very last stop, the top of the ladder, is the federal court, which only hears really important cases. But just remember, an appeal is not a do-over. They're not going to rehear all the evidence. They're just reviewing the first trial to see if the judge made a major legal mistake. So there you have it, the whole journey from that super important pre-litigation prep work through the paper battle of the pleadings, the strategic mini-battles, the trial itself, and finally all the stuff that happens after the judgment. It's a long road, but it has a clear structure. And if you take away just one thing from all this, let it be this. That dramatic trial you see in the movies, that is just the tiny tip of the iceberg. The vast, vast majority of the time, the effort, the strategy, all the real work happens before anyone even thinks about stepping into a courtroom. At the end of the day, the Malaysian civil process is a very meticulous, very structured journey. It can feel overwhelming, for sure, but having the map, understanding these stages, is without a doubt the key to getting through it and protecting your rights. So, we'll leave you with this question. You have the map now. You can see the whole path laid out in front of you, but the real question is, for your journey, what is that first, most critical step you need to take?